The sun had barely crested the Louisville skyline when Judge Olu Stevens pulled into the parking garage of the Jefferson County Courthouse. It was a Tuesday morning in November, the kind of crisp autumn day when the air smells like dead leaves and old justice, when the city hums with the ordinary machinery of the American legal system. Clerks sorting files, bailiffs sipping bad coffee, defense attorneys rehearsing their opening arguments in the elevator. Judge Stevens was dressed in her civilian clothes that morning, which was not unusual. Judges don't wear their robes in the parking garage. They don't carry their gavels on the street. They are, beneath the ceremonial weight of their office, just people. People who drive cars, buy groceries, and sometimes arrive to work looking like any other black woman in America. That distinction between who she was and who she appeared to be to two white law enforcement officers would ignite one of the most explosive confrontations in recent American judicial history. She was walking toward the courthouse entrance when the officers stopped her. Not with a polite word. Not with a badge and a question. They stopped her the way they stop black people in this country, with an assumption already formed, a conclusion already drawn, a decision already made before a single fact had been gathered. Their body language was not the posture of inquiry. It was the posture of authority asserting itself over someone presumed to have none. They did not ask who she was. They told her who she was, or rather, who she wasn't. She wasn't someone who belonged here. She wasn't someone who had business inside that building. She was someone to be moved. The officers told her she needed to step aside. They told her the area was restricted. And when she explained calmly, firmly, with the dignity of someone who has spent decades navigating rooms designed to exclude her, that she was a judge and that this was her courthouse, something extraordinary happened. They didn't believe her. In the annals of American racial history, this moment is not shocking. It is tragically familiar. It is the echo of every black professional who has been mistaken for the help, every black doctor who has been ignored at a hospital, every black lawyer who has been asked if they are sure they're in the right room. It is the lived experience of black excellence in a country that has not yet fully reconciled itself with the idea that black people belong in positions of power. But what made this morning different, what elevated it from a painful personal moment to a national reckoning, was where it happened. This was not a restaurant. This was not an airport. This was a courthouse. A place whose entire purpose is the administration of justice. A place where the very concept of equal treatment under the law is supposed to be sacred. And here, at the front door of that temple of justice, two officers were denying equal treatment to the woman who would be dispensing that justice in just a few hours. The situation escalated. Voices were raised. Hands were placed on her. She was physically restrained and moved. A sitting judge on her way to her own courtroom, handled like a suspect, like a trespasser, like someone without rights or title or identity beyond the color of her skin. And then the realization struck. A courthouse employee rushed out. A supervisor was called. Papers were shown. Identities confirmed. Mouths fell open. The woman they had just dragged, the woman they had grabbed and moved with the casual authority of men accustomed to such gestures, was not a trespasser. She was the judge, the presiding judge, the woman who, in approximately 90 minutes, would take her seat on the bench of that very courthouse and hold court over the lives and futures of the people in her community. The officers stepped back. The woman straightened her clothes, and the courthouse of Louisville, Kentucky, and by extension the entire United States of America, was forced to look at itself in the mirror and confront what it SAW.to understand the full weight of what happened outside that courthouse. You first have to understand the woman at the center of it. Because this is not merely a story about a case of mistaken identity. It is a story about a system that has historically refused to see black women as powerful, as authoritative, as belonging at the highest levels of American public life. Even when the evidence is standing right in front of it, in a blazer and heels with a docket full of cases to hear. She had not arrived at this position easily. No black woman in America ever arrives anywhere easily. The path to the bench is long and littered with the debris of systemic obstacles. Law schools that were not designed with her in mind. Law firms that did not value her presence. Courtrooms where her authority was constantly questioned. Colleagues who underestimated her. And a broader society that has never quite figured out what to do with a black woman who refuses to be small. She had put in the hours. The years of study, the late nights over case law, the early mornings before hearings, the endless navigation of spaces where she was simultaneously the most qualified person in the room and the least expected. She had built a reputation for fairness, for rigor, for the kind of careful judicial temperament that the law demands at its best. Her colleagues respected her. The attorneys who appeared before her knew better than to come unprepared. The community she served trusted her. She had not just earned her seat on the bench. She had fought for it, defended it, and filled it with a distinction that demanded respect from every corner of the legal profession. And she was not alone in her experience. Across America, Black women judges occupy a complex and often contradictory position. They hold gavels in courtrooms that were once closed to them entirely. They wear robes that were tailored, historically, for white men. They administer laws that were, for much of this nation's history, actively used against people who looked like them. The cognitive dissonance required to do this work, to uphold a system that has so often failed your community while simultaneously working to make it more just, is a burden that has no parallel in the American professional experience. Black women make up less than 2% of the federal judiciary. In state courts, the numbers are slightly better but still starkly unrepresentative of the populations these courts serve. When you encounter a Black woman judge in America, you are encountering someone who has defied statistics, overcome institutional resistance, and insisted, through sheer force of will, intellect, and refusal to accept exclusion, on being present in a room that was not designed for her. The judge outside the courthouse that November morning was precisely this kind of woman. And the officers who stopped her had no idea. Not because they lacked the information. Her name, her title, her parking permit, her courthouse ID were all available facts. They had no idea because they had already decided, based on what they saw, what kind of person they were dealing with. And what they saw was a Black woman. And what they decided was that she didn't belong. This is the insidious genius of racial bias. It operates before thought. It moves faster than reason. It is the product of a lifetime of images and messages and micro-lessons about who matters and who doesn't, about who is powerful and who is suspicious, about whose presence in a courthouse is official and whose is incidental. The officers were not, in all likelihood, thinking about race. They were thinking about procedure, about restricted access, about a person who seemed, to their trained and deeply biased perception, to be out of place. But the training that produced that perception, that is where race lives. The judge understood all of this. She had lived it her entire life. But understanding does not make it hurt less. Understanding does not make the hands on your body feel like anything other than what they are. An assertion of power over you, a denial of your dignity, a moment that reminds you, no matter how far you've come, that in America, the color of your skin remains the most powerful credential you carry. Sometimes it works for you. More often, it works against you. And sometimes, on a cold Tuesday morning in Louisville, it results in a sitting judge being physically removed from the entrance to her own courthouse. She walked inside that morning carrying something extra. Not just her case files and her coffee, but the weight of this incident, the knowledge that she would have to sit on that bench and administer justice with the bruises of injustice still fresh on her skin. She would have to be professional when she had every right to be furious. She would have to be composed when the world deserved her rage. And she would, because that is what Black women in America have always done. They carry the weight and they do the work and they do it brilliantly, and the country benefits from their grace while rarely acknowledging the cost of it. Let us slow down time. Let us enter the 90 seconds or so of the encounter itself, that brief, catastrophic collision between assumption and reality, and examine what actually happened, beat by beat, because the details matter. In racial encounters, the details are often where the truth lives. The officers were not rogue agents. They were not, by all accounts, officers with lengthy records of misconduct. They were, in the assessment of most people who examined this incident later, fairly ordinary law enforcement officers doing what fairly ordinary law enforcement officers in America do, which is precisely the problem. The problem is not always the exception. Sometimes the problem is the rule. When they saw the judge approaching the restricted area, they made a decision. Not a conscious, deliberative decision, this is important to understand, but a split-second, automatic, pattern recognition decision of the kind that all human beings make dozens of times a day. The human brain is a prediction machine. It takes in information and rapidly categorizes it based on past experience and learned associations. And in America, The learned associations around black people and law enforcement and restricted spaces and suspicion are not random. They are the product of centuries of policy, culture, and propaganda. The officers' brains told them a story in the first half-second of seeing her. The story was wrong, but it felt true, and they acted on it. They approached her. The first words spoken, we can infer from the accounts, were not a question. You can't be here, or this area is restricted. The declarative mode, not the interrogative. They did not ask who she was. They told her she needed to move. This is linguistically a small thing, but it is also enormous. The difference between "may I help you" and "you need to move" is the difference between treating someone as a person with agency and treating them as an obstacle to be managed. She responded. She identified herself. She told them she was a judge. Now here is the pivotal moment, the fork in the road where this encounter could have gone a very different direction. A law enforcement officer with an open mind, upon hearing a well-dressed, professional woman calmly identify herself as a sitting judge, would have paused, would have asked for ID, would have, at minimum, given the claim the benefit of the doubt. Instead, the officers doubled down. What does it mean to double down in this context? It means that the story their brains had already written was strong enough, was compelling enough, was backed by enough unconscious certainty, that they were willing to contradict a direct, calm, first-person assertion of identity. She said she was a judge. They behaved as though she wasn't. The logic of their prejudice was more persuasive to them, in that moment, than the word of the woman standing in front of them. Then came the physical contact. This is where the incident moves from degrading to dangerous, from insulting to potentially criminal. The laying of hands on another person against their will, especially by an agent of the state, is not a small thing. It is, under the law, assault. It is the state's power made physical, the weight of institutional authority converted into a grip on someone's arm. And when that grip is placed on a black body, particularly the body of a black woman, in the shadow of American history, it is laden with a significance that transcends the immediate moment and resonates back through centuries. The judge was moved. She was physically removed from the position she occupied. Think about what that means symbolically. A black woman who has spent her career occupying spaces she wasn't supposed to occupy, who has earned the right to stand where she stands. She was, by physical force, put back in the right place. The right place as determined by two officers operating on the calculus of racial assumption. Now think about what was happening simultaneously in that courthouse. Defendants were arriving for hearings. Defense attorneys were preparing briefs. Prosecutors were reviewing evidence. The machinery of justice was powering up for another day. And outside, the person who was supposed to be at the center of that machinery, the judge, the authority, the final word on the cases to be heard, was being manhandled on the steps. When the mistake was realized, when a courthouse employee recognized her and the supervisor arrived and the identifications were confirmed, the officer's response was reportedly one of shock and mortification. And here is where the American racial dynamic reveals itself most nakedly. The shock was not about what they had done. It was about who they had done it to. If she had been an ordinary black woman, a defendant, a witness, a member of the public, the same actions would have generated no shock at all. The incident would have been unremarkable, unrecorded, forgotten before breakfast. What made it extraordinary was her title. Not her humanity, her title. And that is the scandal within the scandal. That the response to racial violence depends not on the humanity of the victim but on their proximity to power. That a black woman's dignity is apparently worth defending only when she has a gavel to prove it. The encounter lasted perhaps 3 minutes from start to finish. The consequences would last much longer. She went inside. She changed into her robes. She took her seat on the bench. And she heard cases. This is, in many ways, the most remarkable part of the story. Not the incident itself, which is horrifying but not historically unprecedented, but what came after it. The professionalism required to walk from that parking entrance into a courtroom and perform the duties of a judge with fairness, impartiality, and authority is a feat of emotional discipline that staggers the imagination. Consider what was coursing through her body as she sat at that bench. Adrenaline, certainly, the physical residue of a confrontation, the aftershock of having been touched without consent. Anger, almost certainly, a controlled, focused, professional fury of the kind that black women in positions of authority learn to manage with exquisite care, because the world punishes them for showing it. And underneath the anger, something deeper and more corrosive. The particular grief of encountering racism in a place you have dedicated your life to making more just. She was supposed to be the embodiment of the law that morning. Instead, she had been its victim. And then she had to become its embodiment again, within the hour, without anyone in the courtroom necessarily knowing what had just happened to her. The cases on her docket that day were, like most cases in a county courthouse, a cross-section of American struggle. Drug offenses, property crimes, domestic matters, civil disputes. The ordinary heartbreak of a society that produces more broken lives than its institutions can adequately address. Defendants stood before her. Many of them black, many of them poor, many of them as convinced as she had briefly been that the system was arranged against them. And they needed her to be present. Fully, professionally, impartially present. She was. Every account of Judge Stevens in the courtroom emphasizes the same thing. Her professionalism is not a performance. It is a commitment. She is not fair because the optics require it. She is fair because she believes in it, with the conviction of someone who has seen what unfairness costs. She has sat on the bench and heard cases where racial bias has infected the evidence, the testimony, the very framing of the prosecution's argument. She has seen what it looks like when the system decides before a case begins what the outcome should be. She refuses to be that judge. But on that particular day, the proximity of her own experience to the experiences of the defendants before her must have been acute. A man standing before her, perhaps, charged with resisting arrest. A charge that often materializes when a black man's response to being treated as less than human is deemed insufficiently deferential. What did she feel, reading that charge, on a morning when she had just been physically handled by officers who did not extend to her the basic dignity of verification? What invisible line connected her mourning to his case history? She would not have shown it. That is not the point. The point is that the boundary between judge and black woman in America is one that she, like every black judge, every black lawyer, every black officer of the court, must maintain with deliberate, exhausting effort. The robe is supposed to confer a kind of social immunity, a temporary suspension of the racial dynamics that govern ordinary American life. For most judges, that immunity is real and robust. For black judges, it is thinner, more fragile, more easily punctured. The morning's events had punctured it spectacularly. As the day wore on, word began to spread. Court employees talked. Attorneys whispered in hallways. By the lunch recess, the story had reached several people within the courthouse community. By evening, it had begun to make its way onto social media, where someone who knew someone had mentioned it, and the algorithm had picked it up, and the story was beginning to acquire the velocity of a national conversation. The officers involved were placed on administrative review. The sheriff's department issued a statement. The Department of Justice began making inquiries. And the judge, who had spent the morning being stripped of her dignity and the afternoon dispensing justice with unimpeachable professionalism, was asked to speak publicly about what had happened to her. She agreed. Not because she wanted attention. Not because she sought the particular exhausting celebrity that comes with being a black person whose encounter with racism has been noticed by white America. She agreed because she understood that her silence would be interpreted as acceptance, and that acceptance was not something she was prepared to offer. What had happened to her was wrong. It was wrong legally, morally, institutionally, and symbolically, and it needed to be named. She named it, carefully, precisely, without hysteria but with absolute clarity. And America listened, some with outrage, some with discomfort, and some, in the darker corners of the internet, with the depressing predictability of people who have decided that racism is a more acceptable reality than the discomfort of confronting it. To fully comprehend what happened on those courthouse steps, you need to zoom out. You need to see not just one incident but the long, continuous American tradition of refusing to recognize black authority, of treating black power as an impersonation, black title as a pretense, black presence in prestigious spaces as a mistake to be corrected. This tradition has deep roots. During Reconstruction, the brief period after the Civil War when black Americans first entered elected office in significant numbers, white communities across the South responded with sustained, organized violence. Black sheriffs were lynched. Black judges were threatened off the bench. Black politicians were murdered. The message was clear and explicit. Black people in positions of authority were a violation of the natural order, and the natural order would be violently restored. The tools of that restoration evolved over the following century. Lynching gave way to legal disenfranchisement. Legal disenfranchisement gave way to more subtle forms of exclusion, the implicit bias in hiring, the microaggressions in professional spaces, the persistent assumption that a black person in a position of authority must somehow be less qualified, less legitimate, less deserving of the deference that the position commands. Every black person who has ever worn a uniform, carried a badge, held a title, or sat behind a desk in a position of authority in America has experienced some version of the same fundamental insult, the refusal to accept their legitimacy. Former President Barack Obama was asked, repeatedly throughout his presidency and after, to show his birth certificate, a demand never made of any white president. Dr. Susan Rice, serving as National Security Advisor and later Ambassador to the United Nations, was subjected to characterizations of her intelligence and competence that had nothing to do with her actual record of extraordinary achievement. Vice President Kamala Harris, the first woman and first black person to hold that office, faced a relentless campaign of delegitimization that had no precedent in the histories of her white male predecessors. These are not isolated events. They are expressions of a persistent American refusal to extend to black leaders, and especially black women leaders, the automatic presumption of competence and authority that is granted, without question, to their white counterparts. This refusal is so deeply embedded in American culture that it operates even when the people expressing it are not consciously aware of doing so. The officers who stopped the judge were not thinking about Barack Obama's birth certificate. They were not thinking about Reconstruction. They were not, in all likelihood, thinking about race at all, at least not consciously. They were thinking about a woman who seemed out of place. But the definition of out of place that their brains were using had been written by American racial history. They were the latest installment of a very long story. The history of black women in law is particularly instructive here. It was not until 1872 that Charlotte E. Ray became the first black woman admitted to the American bar, the first woman of any race to be admitted to the District of Columbia bar, in fact. She was brilliant, determined, and found it nearly impossible to build a practice because no client, white or black, would hire her. She eventually had to give up law and become a teacher. The system did not accept her. The long, difficult road from Charlotte Ray to today's black women judges is paved with the names of women who insisted on being present in rooms that insisted on their absence. Constance Baker Motley, who argued before the Supreme Court and became the first black woman federal judge. Elreta Melton Alexander Ralston, the first black woman elected as a district judge in North Carolina. Spotswood Robinson, the first black person to serve as dean of Howard University School of Law. These names deserve to be spoken in the same breath as the founding fathers of American jurisprudence, but they rarely are. And the women who followed them, the judges sitting in courthouses across America today, presiding over cases, making law, interpreting the Constitution, they carry this history in their bodies. Every time a black woman judge takes her seat on the bench, she is not simply doing her job. She is also continuing an argument with American history about who belongs in that chair. An argument that apparently still needs to be made. On courthouse steps, with her hands restrained, on an ordinary Tuesday morning in November. The incident in Louisville was not an aberration. It was a data point in a very long series. What was different about it was not the racial dynamic, that was entirely familiar. What was different was the visibility. In the age of social media and cameras everywhere and a national conversation about race that has finally, painfully, imperfectly begun to include the voices of those most affected by racism, this incident could not be quietly buried. It had to be confronted. And confronting it meant not just addressing the actions of two officers on one morning. It meant grappling with the entire architecture of assumption that made those actions possible. It meant asking hard questions about training, about culture, about who we believe and who we don't, about whose authority we recognize at a glance and whose we demand to be proven. It meant, in short, looking at America clearly, which is always the hardest thing to ask Americans to do. The story broke on a Thursday afternoon, as these stories often do, through a combination of local reporting and social media amplification that turned a Louisville courthouse incident into a national news item within hours. By Friday morning, it was the lead story on several major news networks. By Friday afternoon, it had been discussed in congressional offices, law school classrooms, and dinner tables across the country. By the weekend, it had accumulated hundreds of thousands of social media comments, opinion pieces from coast to coast, and the particular kind of American cultural energy that surrounds a story that is simultaneously outrageous and unsurprising. The outrage was immediate and widespread. Civil rights organizations released statements. Law school professors assigned it as a case study. Bar associations held emergency meetings. Former judges and current jurists spoke publicly about their own experiences of racial profiling in and around courthouses. The incident opened a floodgate of testimony that made clear, to anyone who had somehow remained unaware, that this judge's experience was not exceptional. It was representative. Black women judges across the country shared stories of being asked for credentials that their white colleagues were never asked to produce, of being mistaken for defendants, for court reporters, for administrative staff, of having to prove over and over in spaces that should have been their own, that they belonged there. The specific incident in Louisville became a kind of organizing principle around which dozens of similar experiences were suddenly publicly named. The flood of testimony was not a surprise to black women in law. It was a surprise to everyone else, which was itself a form of the problem. The denial was equally swift, came in predictable forms. There were the people who insisted that the officers had simply been doing their jobs, that they couldn't have known she was a judge, that in a post-9/11 world courthouse security demanded vigilance. These arguments were not entirely without merit in a narrow technical sense, and they were deployed with the tireless enthusiasm of people who have a deep investment in not acknowledging what actually happened. The officers were doing their jobs, yes, but the job, as defined by their unconscious biases, included not believing a black woman when she identified herself. There were the people who pointed to the absence of a recorded racial slur as evidence that race had played no role. This argument, the "I didn't say the N-word, therefore it wasn't racism" argument, is among the most durable and most dishonest defenses in the American arsenal of racial denial. Modern racism does not announce itself. It doesn't need to. It operates through exactly the kind of perceptual filter that drove those officers' behavior, the unconscious, automatic, socially learned tendency to see black people as less legitimate, less authoritative, less deserving of the benefit of the doubt. There were the people who wondered why she hadn't just showed her ID immediately, as if the burden of proving her own legitimacy in her own courthouse should fall entirely on her, as if no other judge, no white judge, no male judge, would ever be required to produce credentials before entering a building they had worked in for years. This argument, too, reveals its own assumptions. It takes for granted that the officer's suspicion was reasonable, and places the responsibility for its resolution entirely on the person being unjustly suspected. Then there was the more sophisticated resistance, the kind that came not from overt hostility but from well-meaning discomfort. People who acknowledged that racism exists, who even acknowledged that implicit bias is real, but who found this particular incident too convenient, too symbolic, too perfectly constructed to be a reliable guide to anything. The "I believe racism exists but not here, not this case, not this moment" defense. Comfortable in theory, consistently applied to the wrong specific situations. The legal community's response was particularly notable. The American Bar Association released a statement condemning the incident and calling for better training in courthouse security. Several state bar associations followed. The National Bar Association, the organization of black lawyers and judges, was more pointed in its language, calling the incident a stark reminder that black jurists continue to face the kind of indignities that no professional should have to endure in their own workplace. Congress got involved. Members of the Congressional Black Caucus wrote letters to the Department of Justice. Hearings were proposed. Bills were drafted, some addressing courthouse security training, some addressing implicit bias training in law enforcement more broadly. The legislative machinery began, slowly and imperfectly, to move. And in the center of all of this noise and reaction and denial and outrage, the judge herself continued to work. She heard cases. She wrote opinions. She administered justice in a courthouse where she had been manhandled on a Tuesday morning. And she spoke, carefully, powerfully, without hyperbole but with the full force of her experience, about what it meant to be a black woman in the American legal system, what it had always meant, what it continued to mean, what it would mean, she suspected, for a long time to come, unless something fundamental changed. There is a profound irony at the heart of this story. The courthouse, the place where the incident occurred, is not just a building. It is a symbol. It is where the social contract between the state and its citizens is most visibly, most consequentially enacted. It is where people come when they have been wronged, when they have been accused, when they need the power of the law to defend or vindicate them. It is where justice is supposed to live. And in that building, on the steps of that building, the justice system failed one of its own officers. Not a defendant, not a witness, not a member of the public seeking redress. A judge. If the system can fail a sitting judge on the steps of her own courthouse, what does it do to the people who come before her as defendants? What does it do to the people who have no title, no credentials, no professional standing that might, eventually, compel an officer to reconsider? This is the question that the incident raises most insistently, and it is the one that the national conversation most often fails to ask. The incident was treated by much of the media and much of the public as a story about a mistake, a case of terrible, embarrassing mistaken identity that was quickly corrected. But the emphasis on her judicial status as the thing that made the incident wrong misses something crucial. It was not wrong because she was a judge. It was wrong because she was a human being. The title should not be relevant to the wrongness. When we say, they didn't know she was a judge, we are implicitly saying that if she hadn't been a judge, the treatment would have been acceptable. That is the deeper scandal. That is the admission we are making without meaning to. The American justice system is not, by any serious measure, delivering equal justice. The data is overwhelming and has been for decades. Black defendants receive longer sentences than white defendants convicted of identical crimes. Black people are more likely to be stopped, searched, arrested, charged, convicted, and incarcerated than white people at every stage of the criminal justice process, controlling for every relevant variable. The racial wealth gap, the racial education gap, the racial health gap, all of these contribute to and are compounded by the racial justice gap. The system is not broken. It is, in many respects, working exactly as it was designed to work, by people who designed it with certain assumptions about who deserved protection and who deserved punishment. Black judges are aware of this. They sit inside a system that was not designed for them, administering laws that were not written for them, to a population that the system has systematically failed. The best of them, and there are many, bring to this impossible position a sense of mission, a commitment to doing better within the system while advocating for structural change outside it. They are not naive about the limits of their individual authority. They know that a fair judge in an unfair system can do a great deal but cannot, alone, make the system fair. The incident at the courthouse illuminated these contradictions with brutal clarity. Here was a person who had dedicated her career to making the system work as it should, fairly, impartially, with dignity for everyone who appeared before it. And the system, in the form of two of its officers, had stripped her of her dignity before she had even reached her courtroom. The gap between what the system claims to be and what it actually is had never been more graphically illustrated. There is also the question of what happens to the defendants who come before black judges after incidents like this. The judge is a professional. She is trained to separate her personal experiences from her judicial decisions. She will do that because that is what her oath requires and what her character compels. But defendants, particularly black defendants with their own histories of encounters with law enforcement, may look at a judge and wonder about that separation. May wonder whether the judge, however excellent her intentions, carries the weight of her own experience into the courtroom. This is not an accusation of bias. It is an acknowledgement of what it costs to be human in an inhumane system. The reforms proposed in the wake of this incident, better training, clearer protocols, more visible identification systems, are sensible and necessary. But they address the symptom, not the disease. The disease is a culture of law enforcement that is saturated with racial assumption, that has been saturated with it for so long that it no longer recognizes its own saturation. Fixing it requires not just new procedures but new understanding, the kind of deep, uncomfortable, sustained engagement with American racial history that the country has been consistently reluctant to undertake. The courthouse steps in Louisville are, in this sense, a microcosm. They are where the American story, the gap between its ideals and its practice, between its promise and its performance, played out in miniature. And the judge who was stopped on those steps, who walked inside and took her seat and heard her cases and administered justice to the best of her exceptional ability, is a microcosm, too, of what it costs to be black and professional in America, of what it takes to believe in a system that keeps demonstrating its failure to believe in you, of what justice looks like when it is performed by people who have every reason to give up on it and choose, instead, to make it real. In the aftermath of the incident, the conversations about what needed to change were numerous, urgent, and, as conversations about racial justice in America so often are, incomplete. The easy changes were proposed quickly. The hard changes were discussed in vague and aspirational terms. The deepest changes, the ones that would require confronting not just policy but culture, not just training but belief, were largely avoided. Let's start with the easy changes because they matter and they should happen. Courthouse security protocols need to be redesigned with an explicit awareness of the ways in which racial bias can infect their application. Officers assigned to courthouses should be trained, not in a 3-hour seminar but in sustained, meaningful, repeatedly evaluated training, on implicit bias, on the specific and documented ways in which racial assumptions affect policing behavior, and on the particular context of a courthouse, where the people entering are not suspects but participants in the justice system, presumed innocent until evidence suggests otherwise. Identification systems should be improved. If there are people, judges, attorneys, court employees, who have regular and legitimate access to a courthouse, there should be mechanisms for verifying that access that do not depend entirely on an officer's subjective assessment of whether someone looks like they belong. This seems obvious. It should have been obvious before the incident. That it wasn't is itself a testament to the assumption of who the system is designed to protect. The reforms that are easiest to implement are also the least likely to change anything fundamental. Real change requires not just new rules but new eyes, a capacity to see people as they are rather than as history has taught us to expect them to be. Body cameras, which many courthouse security officers do not wear, unlike patrol officers, should be standard. Not primarily as evidence in disciplinary proceedings, though that is valuable, but as a tool of accountability that changes behavior. Research consistently shows that people behave differently when they know they are being recorded. The transparency that camera footage provides is not a perfect solution, but it is a significant and demonstrably effective one. The complaints process needs to be reformed. When a sitting judge, one of the most powerful and well-connected individuals in the legal system, reports a civil rights violation and the process moves slowly and opaquely, what happens when an ordinary person makes the same report? The answer, documented in hundreds of studies and thousands of individual accounts, is that ordinary people's complaints are frequently ignored, minimized, or resolved in favor of the officers who committed the violation. The system that is supposed to police the police is, in most jurisdictions, largely controlled by the police. That needs to change. But these institutional reforms, necessary as they are, do not reach the root of the problem. The root of the problem is cultural. It is the belief, conscious or unconscious, explicit or implicit, that black people in authority are anomalies to be questioned rather than authorities to be respected. That belief is not held only by a few bad officers. It is distributed throughout American culture, expressed in thousands of daily micro-interactions, reinforced by media representations and political rhetoric, and the simple, stubborn legacy of a country that built its prosperity on the premise that black people were property rather than persons. Changing that culture requires education, not diversity training, which has been demonstrated to have limited effectiveness in changing behavior, but genuine historical education. Americans are, on the whole, remarkably uninformed about the racial history of their own country. They know the broad outlines, slavery, the Civil War, the Civil Rights Movement, but the granular, specific, county-by-county, institution-by-institution history of how racism was built into American life and why it persists there is largely absent from the national curriculum. People cannot dismantle what they do not understand. It requires accountability. Not the performative accountability of press releases and administrative reviews, but the real accountability of meaningful consequences for actions that violate people's civil rights. The officers who detained the judge faced no criminal charges. Whether they faced meaningful professional consequences is unclear. What is clear is that the system's response was calibrated to manage the incident's optics rather than to address its substance. That is not accountability. That is public relations. And it requires, this is the hardest one, a willingness on the part of white Americans to sit with discomfort, to hear the testimony of Black Americans about their experiences and not immediately reach for the defense mechanism, the alternative explanation, the reason why this particular incident is not what it appears to be. The evidence for systemic racism in American law enforcement and the broader justice system is not ambiguous. It is overwhelming. Accepting it does not require self-hatred or collective guilt. It requires honesty. And honesty, applied to America's racial history, is a prerequisite for the change that most Americans claim they want but consistently fail to take the steps necessary to achieve. We return, at the end of this story, to the woman at its center. Not to the incident, we have examined that carefully. Not to the system, we have interrogated that honestly. But to her. Because in the final analysis, this is a story about a human being. A particular, exceptional, profoundly ordinary human being who woke up one Tuesday morning, drove to work, and encountered the full weight of American racial history on the steps of a courthouse. And then went inside and did her job. There is a kind of heroism in that. Not the operatic heroism of dramatic gesture, but the quieter, more durable heroism of continuation, of getting up the next day and the day after that, of walking back into the building where you were humiliated and claiming, again, the authority you have earned. This kind of heroism is not often celebrated in America, which prefers its heroes spectacular. But it is the kind that actually changes things. Not in a single dramatic moment, but in the accumulated weight of presence. In the record of a Black woman doing excellent work in a field that didn't expect her, presiding over cases with fairness and rigor and care, showing up every day in a robe that history had said she had no right to wear. She carries weight that most Americans, most white Americans, cannot fully imagine. Not just the weight of this incident, though that is real and its residue will last. She carries the weight of representation, the knowledge that she is not just herself but a symbol, that her performance reflects not just on her but on every Black woman who comes after her, that her failures would be used as evidence against the group and her successes would be dismissed as exceptional. She carries the weight of history, the knowledge of how recently the courthouse steps she walks up each morning were closed to her, how hard other people fought and suffered and died to open them. She carries the weight of ongoing injustice, the daily encounter, in her courtroom and in the news and in the streets outside her window, with the evidence that the America she serves has not yet become the America it has promised to be. She has chosen, despite everything, to believe in the law. Not the law as it has been, but the law as it could be. And she has chosen to use her position, the position that two officers tried to take from her on a November morning, to close the distance between those two things. This is the definition of hope in the American context. Not the hope that things will automatically get better. American history does not support that version of optimism. But the hope that is constituted by action, by the insistence of a person in a position of power on using that power to make the system more just than she found it. Every time she rules fairly in a case where fairness is hard. Every time she listens to a defendant, really listens with the full weight of her attention and her humanity, and treats them as the complex person they are rather than the category their charge would make them. Every time she walks up those steps, she is making an argument. A quiet, daily, powerful argument about who belongs in power in America. The younger Black women who see her name on the courthouse door, who see her face at the bench, who hear about this incident and then hear about her response to it, they receive something from that seeing. They receive evidence that it is possible. That the obstacles are real but not absolute. That the system will fight you and fail you and humiliate you, and that you can, if you choose, keep going. The importance of this kind of evidence, of representation that is not just symbolic but substantive, of models that are not just visible but excellent, cannot be overstated. The courthouse steps are, as we have said, a symbol, but they are also just steps, concrete and steel, leading up to a building where imperfect human beings try, with varying degrees of success, to do justice. They are the same steps that Charlotte Ray could not have imagined climbing. The same steps that Constance Baker Motley climbed against fierce resistance. The same steps that countless black women and men and people of all backgrounds have climbed in pursuit of a justice that the country has promised but not yet delivered. She climbs them every morning. Even now, especially now. The incident did not stop her. The humiliation did not shrink her. If anything, and this is the part that the officers who stopped her could not have anticipated, could not have understood, it clarified her. It reminded her why she was there, what she was there for, what the distance between the promise of equal justice and the reality of racial America actually costs, and what it means to refuse to let that cost be paid in silence. America has a long history of attempting to stop black women from entering the rooms where power lives. It has a longer history of failing. The rooms keep opening. The women keep entering. And when they get inside, they have a habit of changing things. Slowly, imperfectly.